Hello friends, in the series on the income tax cases, today we will discuss the case of Santosh Jain versus income tax officer. This case has been reported in 108 ITR Tribunal and the matter has been decided by Raipur ITAT and the date of the judgment is 24th August 2023. As all we know that there are certain circumstances in the income tax proceedings that if an assessee has done some mistake, then there are more than one penalties for the same mistake, or there are circumstances when due to one mistake the assessee has not complied with the other law, then on the assessee for every mistake the penalty is levied. So if this type of situation comes before the assessee, then what is the law for imposing the penalties? This is the best case for understanding the penalty provisions. In this case, the assessee was a manufacturer and trader of steel. The assessee do have substantial turnover. The assessee was not maintaining its books of accounts. The assessee has not get his accounts audited under the Income Tax Act under section 44 AB, and the assessee has not filed his return of income even. The notice under section 148 was issued to the assessee. The assessee even did not comply with the notices, and due to which the best judgment assessment under section 147 read with section 144 was done on the assessee. During the assessment proceedings, the learned assessing officer found that the assessee has not maintained books of accounts and has not get his accounts audited. That's why the assessing officer levied penalty for both the provisions under section 271A and section 271B. Section 271A penalty is for not maintaining the books of accounts, and section 271B is for not getting the accounts audited. The assessee challenged the second penalty, which was not for getting its accounts audited. It was the plea of the assessee that when you have levied a penalty under section 271A, which is there for not maintaining the books of accounts, so I should not be saddled with the another penalty. Because if I have not maintained the books of accounts, then it is not possible for me to get the books of accounts audited. So the penalty under section 271B for not getting the books of accounts audited should not be levied on me. But the CIT appeal was not convinced with the assessee and he go ahead with imposing the penalty. When this matter came before the ITAT by relying on the judgment of Commissioner of Income Tax versus S.K. Gupta, which was reported in 322 ITR at page number 86 and which was decided by Allahabad High Court. In that case, the court was of the opinion that if the penalty under section 271A has been imposed on the assessee for not maintaining its books of accounts, then the assessee should not be saddled with another penalty under section 271B for not getting his books of accounts audited, because once the assessee has not maintained the books of accounts, then it is not possible for him to get the books of accounts audited. So both the penalties at the same time cannot be levied. Friends, at the face, if we see the circumstances and the facts of the case, it appears that both the penalties should be levied, because maintaining books of accounts is a crime, not maintaining the books of accounts is a crime, and even not getting the books of accounts audited is a fault of the assessee, and it is not non-compliance of the provisions of the Income Tax Act. But the jurisprudence on this point is there. The courts are of the view that both the penalties should not be levied. So we can take the help of this decisions also and the decision of the Allahabad High Court also in the case of CIT versus S.K. Gupta, which was reported in 322 ITR at page number 86. At the end of this video, once again, I am repeating the name of the case. The name of the case is Santosh Jain versus Income Tax Officer, and this case has been reported in 108 ITR Tribunal at page number 636. The matter has been decided by Raipur ITAT and the date of the judgment is 24th August 2023. Thank you, friends.